students. The topic which is assigned to me for a discussion is on Indian constitutional law and new challenges. The topic basically deals with right to equality, liberalization, privatization, and its impact on affirmative action program plan of the state, women empowerment, freedom of press, conflicting issues and challenges, and scientific research and development with reference to freedom of speech and expression. When we will be discussing this topic, namely right to equality, freedom of speech and expression, impact of privatization on affirmative action program plan, freedom of press, and scientific development, let us not forget the role of the state in all these aspects. The role of state is extremely important when it relates to right to equality, when it relates to affirmative action program plan, when it relates to freedom of press and scientific research and development in relation to freedom of press. So one should not ignore the role of state in this context. So we must understand what kind of role the state is playing in ensuring these rights, particularly right to equal opportunities, right to affirmative action, and right to freedom of speech and expression. So dear students, one must understand what do you mean by state? See, the concept of state is very well defined in terms of Article 12 of the Constitution of India. One must have a cursory glance to the definition of state in context to Article 12. Article 12 of the Constitution of India defines the state. It states that state means central government, state government, and any other entity which involves the instrumentality of the state. Why it is necessary to discuss the definition of the state? Because please understand, the state is very, very important. Without the state, one cannot expect right to equality, one cannot expect right to equal opportunity, one cannot expect right to affirmative action, one cannot expect right to freedom. So without state, these rights are meaningless. These rights are useless. So one must appreciate, one must understand, and one must analyze the concept of state in relation to these fundamental rights. Correct? And one must understand the role and functioning of the state in the era of liberalization, privatization, and globalization in context to these fundamental rights. As I said, Article 12 of the Constitution of India defines the state. As I already said, state will mean central government, state government, and any other instrumentality which involves the instrumentality of the state. In other words, it includes any other entity which is subject to legislative control, administrative control, and financial control of the state. At the first instance, the concept of the state is extremely relative. Extremely relative. If you will ask this concept to a student of political science, he will say the state is something which governs the people. According to him, there will not be any difference between the legislative body, executive body, and judicial body. For a student of political science, judicial body is equally a state. But when this question is posed or raised to a student of law, he will say the concept of state differs from chapter to chapter of the Constitution of India. So if you look at the definition of the state in terms of Article 12, it is in relation to fundamental rights. So the term state, which is defined under Article 12, has its limitation, has its restriction only in context to fundamental rights. So the definition of the state as defined under Article 12 cannot be overstretched for other chapters which are there under our Constitution. So concept of state in context to fundamental rights is different. Concept of state in context to directive principal policy of the state is something different. And the concept of state in context to federalism is something different. Very important. You must understand how the state differs from chapter to chapter of the Constitution of India. When it comes to chapter on fundamental rights, we have a limited interpretation of the concept of state. As far as fundamental rights are there, you know very well. The preamble of our Indian Constitution ensures liberty, equality to all its people of India. Ensuring fundamental rights is one of the important purpose of our Constitution of India, and that is clarified in our preamble. So the preamble clearly said that ensuring liberty, equality will be an important aspect, will be an important purpose of the Constitution of India. Now, it is whose duty to protect those fundamental rights? There's a famous case called Golaknath versus State of Punjab, wherein Justice Patanjali J has rightly observed the definition of the state and the definition of the fundamental rights. He opined that, and I quote, the fundamental rights are those rights which are enforceable by the state against itself. So you cannot enforce the fundamental rights against the private entity. It is the duty of the state to protect the fundamental rights, which include right to equality, right to equal opportunity, right to affirmative action, and right to freedom of press. So these are the responsibility of the state to protect those fundamental rights. Now, when you comment on fundamental rights, there are certain fundamental rights which are open to all. Like Article 14, right of equal opportunity, right of equality, open to all. Article 15, access to public place. This is open to all people, irrespective of the nationality. But when it comes to equal opportunity, Article 16 clearly provides that this fundamental right is available only to citizens of India. When it comes to Article 19, freedom of speech, again it has its limitation. It says that it is available only to citizens of India. Now, when I say freedom of speech, it also includes freedom to have an access to the governing affairs of the state. Now, often it is said that all fundamental rights are human rights. We have one of the important documents called UDHR, Universal Declaration of Human Rights. Right to take a part in the governing affairs of the state, if I'm not mistaken, in terms of Article 28 of the UDHR, clearly state that right to take a part in the governing affairs of the state is one of the important human rights. And if you will go through all our fundamental rights, you will come to know these fundamental rights have been driven, have been influenced by the document called Universal Declaration of Human Rights. Right? So there's an impact of UDHR on these fundamental rights. Correct? Then, these fundamental rights extremely analogous to that of
Ma'am, I
human
have
rights.
taken the attendance.
So Human rights are analogous to
I've
the
taken the
fundamental
attendance.
rights.
Sorry, my phone wasn't
All fundamental rights are
because there are
nothing but the human rights. Coming back to Article 21, as it said, right to life and liberty. This fundamental right is again open to all, irrespective of any nationality. So does with the religious freedom, Article 25 and Article 26. We have Article 32, right to approach the constitutional court, including writ jurisdiction of the Supreme Court. So when my fundamental rights are violated, I have a right to approach the Supreme Court. So now this right is available to all. If a foreigner is there and if his fundamental rights are violated, he can directly approach the Supreme Court. Now the point is that in terms of Article 12, but we talk about the concept of state, it has got its very, very limited application. If your fundamental rights are violated, Article 32 clearly provides that you can go directly to the Supreme Court and you can file a writ. But against whom? The writ cannot be filed against the private entity. More importantly, you cannot file a writ against the legislative body because legislative body is not a state within the meaning of Article. You cannot file a writ against the High Court and Supreme Court for the violation of your fundamental rights. Yes, if the High Court passes an order which goes against you, you can always challenge by a special leave petition in terms of Article 136 of the Constitution of India. Okay, so my point is that when you talk about concept of state in context of fundamental rights, it has got its limited application. Correct? So legislative body is not a state within the meaning of Article 12. Judicial body is not a state within the meaning of Article 12. So what comes under state in terms of Article 12, and that definition is very important when it comes to the fundamental rights like right to equal opportunity, right of freedom of place, so on and so forth. Private entities are not a state, legislative bodies are not a state, judicial bodies are not a state. So legally speaking, executive authorities comes under the definition of the state for the purpose of Article 12. Now, let us go back to Chapter 4 of the Constitution of India. The Chapter 4 of the Constitution of India deals with directive principal policy of the state. At the first instance, let me clarify you that fundamental rights are enforceable by law, but directive principal policy of the state are not enforceable by law. But there are some articles in our directive principal policy of the state have been made enforceable in the light of fundamental rights. Say, for example, we have Article 47, which imposes responsibility on the state to ensure the health of the people. That article has been made enforceable by the government, by the court, as much as responsibility of the state to ensure the health also amounts to right to health in terms of Article 20. And if you look at Article 25 to Article 28 of the Universal Declaration of Human Rights, it clearly provides that right to health, including physical and mental, and adequate standard of living of the people have been regarded as one of the important human rights. Okay, so in terms of Article 21 and in terms of Article 25 to 28 of the Universal Declaration of Human Rights, right to health is not only a fundamental right, but it is also the human rights. So on one hand, right to health is a fundamental right as well as human rights. On the other hand, it imposes the duty on the state in terms of Article 57 to protect the health of the people. So technically speaking, articles which are contained under the directive principal policy of the state remain in the governance of the state. They are not enforceable by the court of law in India, but they are made enforceable as much as they are linked with the fundamental rights. They are linked with the human rights. Now, we've got another article like Article 48 and Article 48A. Duty of the state to protect the forest, duty of the state to protect the environment. Now, these articles are again made enforceable because they are linked with Article 21. Right to clean environment has been recognized as one of the important fundamental rights, and it is equally duty and responsibility of the state to protect the environment. Now, my point is that the concept of the state as it is understood for the purpose of chapter 4 is much more wider than the concept of state as it is understood for the purpose of chapter 12. Chapter 3. Chapter 3, as you know, it deals with the fundamental rights, and the definition of the state is very limited. Now, when you talk about chapter 4, as it deals with the directive principle policy of the state, it also talk about various categories of the state. In other words, it basically talks about the duties and responsibilities of the state. Now, if you look at the various provisions of the directive principle policy of the state, you understand the duties and responsibility of the state. Let's have a cursory glance of these few articles, like duty of the state to ensure equal pay for the equal work, responsibility to ensure livelihood, responsibility to ensure equal distribution of income and wealth, responsibility to ensure social security measures to different label people, senior citizens, responsibility to ensure just and human condition, to ensure maternity benefit, to ensure employees' participation in terms of Article 43A, to ensure uniform civil code in terms of Article 44, to ensure free and compulsory primary education in terms of Article 45, to ensure economic justice in terms of Article 46, to ensure adequate standard of living, that is health to the people, in terms of Article 47, to ensure the environment, to ensure the forest, in terms of Article 48, 49, and then to ensure the separation of power between the executive and judiciary in terms of Article 50. So when we talk about this, to ensure, it basically refers to duties and responsibilities of the state. Now, what kind of state we are referring to in terms of Part 4 of the Constitution of India? Here, the concept of state is much more wider than the concept of state for the which is there in terms of Article 12. Now, for the purpose of Part 4, the concept of state is wider as much as it not only includes the executive authority, but also includes judicial authority and also includes legislative power. You see the provisions.
Sanjay
Ah,
sir, speak little loudly and your mic will be with, nearby mouth instead of there is a difference. So you are not clearly audible. So
okay.
yeah.
Am I audible?
Yes, sir.
So,
Yes.
so as I said, concept of state for the purpose of chapter 4 is much more wider than the concept of state for the purpose of chapter 3. Correct? Now, for the purpose of chapter 4, state not only includes the legislative body, but also includes executive body and judicial body. So if you look at the duty and responsibility of the state to ensure equal pay for the equal work, equal distribution of income and wealth, now this cannot be done except by the legislative body. And therefore you will find you have a number of welfare legislations like Equal Remuneration Act, Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act. Okay. Then duty to ensure what you can say just and human condition. Therefore, you will find the legislation like the Factories Act to ensure the just and human condition. This cannot be done except by the legislative body. Maternity Relief Act. This law is made by the legislative body. So when you talk about certain welfare sentencing measures, it is expected that the legislative body will do it. Of course, the executive bodies do it by various policies. My point is that when you talk about these welfare sentencing measures, we're basically concerned with the legislative body. We cannot have a welfare unless and until we have got very good laws and policies in India. So we have got various welfare sentencing legislations, like we have a Senior Citizenship Act, we have a Maternity Benefit Act, and we have other level welfare legislations. And therefore, it has imposed the chapter on directive principal policy of the state has imposed the responsibility on the state. And which kind of state we are referring to? We are talking about the legislative body. The legislative body has enacted various suitable laws and policies in India. And then, in terms of Article 50, as I said, it not only imposes duty on the executive body, but also imposes duty on the judicial body. So my point is that the concept of the state, which is there for the purpose of Part 3, is very limited. And when it comes to concept of state for the purpose of Part 4, it is more wider. Now, let us apply that concept of state in various kinds of fundamental rights, which is the discussion of today's lecture. Now, before we talk about the concept of state and its role in context to the fundamental rights, understand one thing: we have got another concept called federal state. We have a concept of federalism in terms of legislative business. Article 245 to Article 254 of the Constitution of India, along with Schedule 7, clearly highlight the federal characteristics of our Indian Constitution. So the federal state has got equal power to make certain legislations in terms of list 2 and in terms of concurrent list of Schedule 7. So when we talk about the state, it includes, no doubt, the various kinds of state governments in India. It includes the central government, and it also includes the statutory corporations, like most of the PSCs, most of the government companies, most of the educational institutes which are taking aid from the government. It also includes the federal states. It also includes the legislative bodies. It also includes the judicial body, and it also includes the executive authorities. So the President of India, the Governor of the state, Chief Minister, Council of Ministers, Prime Minister, Cabinet Ministers, all comes under the umbrella of the state when we have a wider interpretation of Part 4 and Part 3 of our Constitution of India. Correct? Now, the most important concept is a right to equality. Please understand one thing. It is the state which is ultimately responsible to ensure right to equality. See, there are two terms when we talk about equality. Right of equality, and second one is right to equality. Correct? Now, before we discuss right of equality and right to equality, let us think about equity and equality. Okay? I always say that no fundamental rights are absolute, including right of equality, right to equality, right to life and liberty, right to freedom of press, so on and so forth. So these fundamental rights are not absolute. They are relative, they are conditional, and they are subject to reasonable restrictions of the state. So,
Sir, can you little bit up your mics? Yeah. Yes, sir.
आता येतोय का?
Yes, sir.
So, ma'am, please tell me if I am not audible. Just tell me.
Yeah, ma'am. Yes, sir. Sure.
So, when we talk about right of equality and right to equality, there is a difference. Correct? Now, let us not discuss that concept right now. First, understand equity and equality. Understand one thing. Equality basically refers to what we can say. It's basically of a legal concept. When you talk about equity, equity is a concept of the common law. Equity is a concept of what we can say. We can say it is a subject of judicial creativity. The principle of equity and the principle of equality both are different. Now, we have a maxim called damnum sine injuria and injuria sine damnum. And it also reminds me section 9 of the CPC. See, why am I discussing? Because one must understand how the principle of equity is relevant and how it is different from the principle of equality. I'm going to give you the example of equity and equality, then you'll understand how equity is different from the equality. So, to clarify the concept of equity, we have a famous maxim called injuria sine damnum and damnum sine injuria. Correct? Means when your legal rights are violated, you can file a case in the court of law. And when your legal rights are violated, Section 9 of the CPC comes into picture. Section 151 of the CPC comes into picture. Correct? Now, law further says that even though you are entitled to have certain relief, it is always at the discretion of the court. Say, for example, if A has given 1 lakh rupees to B and B has to return it back to A has a right to file a case against B. So A can file a summary suit in terms of Order 37 Rule 2 of the CPC. Okay? Or if B is in the possession of the property of A can file a case for the recovery of the possession of the property as against B. So here Order 2 of the CPC is very important. Order 2 of the CPC talk about the framing of the suit. It clearly provides that you must claim all the relief which you are entitled to have. So you may claim for the relief like injunction, court receiver, possession, damages, cost of the litigation, etc. and etc. Correct? Despite of all those facts that you are entitled to claim all those relief, Section 20 of the Specific Relief Act clearly provide that the grant of this relief will be at the discretion of the court. This is called as equity. This is called as equity. Anything which is at the discretion of the court is called as equity, and this is what it is clarified by Section 20 of the Specific Relief Act. So you can't expect that even though my legal rights are violated, it will be protected. It is always at the discretion of the court to grant a relief or not. Okay. Now, when we talk about equality, it is something linked with the rule of law. It is something linked with the natural justice. Now, there are various theories of law. Like divine theory of law, analytical theory of law, law as a system of rule, correct? Law as a practice. Now, divine theory of law is one of the popular theories. Wider interpretation of this theory says that every person by birth is equal. Wider interpretation of this theory provides that audio alterum partem. Now, this reminds me Section 18 of the Arbitration Act of 1990. State that arbitrator is bound to ensure what is called as equal protection and equal treatment to all parties to arbitral proceeding. Article 311 to Article 315 of the Constitution of India provide that you cannot remove any civil servant unless and until you are given an opportunity of being heard to those people. So this is called as equality. Under any circumstances, one cannot be deprived of for equal protection, equal treatment. This is possible only when there is a rule of law. What is rule of law? See, the concept of rule of law is equally relevant when it comes to equality. Okay, equality is possible only when there is a rule of law in your own country. You can't expect the equality when there is no rule of law. What does the rule of law basically mean? The essay on administrative law has rightly said that in UK, although we do not have a written constitution, but still we have a rule of law which is more powerful than any other written form of constitution. In doing so, he said that rule of law would mean everybody is equal before the law, including prime minister to constable. So that is called as equality. Everybody is equal before the law. No one can be punished unless and until opportunity of being heard has been given to that person. And then no person shall be a judge of his own cause. This is also called as a rule of law. Now we have a rule of law in our Indian Constitution. We have Article 32. We have Article 226. We have Article 136. These are the various provisions of the Constitution of India which imposes the duties and responsibility on the judiciary to protect the fundamental rights of the people. That ensure the rule of law. There are various facets of rule of law. And one of the facets of the rule of law says that it shall be duty of the court to protect the fundamental rights of the people. And the rule of law further amplifies that everybody is equal before the law. So treating everybody equal before the law is an equality. Ensuring natural justice to everybody is an equality. Ensuring what is called as the audio alternate partner is an equality. Okay. But at the end, whether to give you relief or not, it is always at the discretion of the court. It is always at the discretion of the judiciary. That is called as equity. Okay. So when you talk about equality, it will include equality before the law or the equal protection equity. When it comes to equity, it says that the relief is always at the discretion of the court. Whether you will get the relief or not, the court will decide depending on the facts and circumstances of each case. So you must understand the basic difference between equality and equity. Now there is a difference between right of equality and right to equality. There is a difference between equality and equity, which I had already discussed with you. Now there is a difference between right to equality and right of equality. Right? Now, Article 14 is a classic example of right of equality. Article 14, 15, and 16 is a classic example of right to equality. Now, right to equality has been held to be a basic structure of the Constitution of India by the Supreme Court. Now, we have various case laws. I think you people may be aware, being a student of law, like Sajjan Singh case, Sankari Prasad case, Golaknath case, Keshav Bhatti's case, and Minerva Mills case. Now, what can be amended and what cannot be amended? We thoroughly discussed in all those cases. When matter was actually discussed in the Keshav Bhatti's case, safely concluded that the basic structure cannot be amended, cannot be altered. Now, what amounts to basic structure is a question of fact. But for the sake of brevity and connivance, I would say that right to equality, which include 14, 15, and 16, Article 14 to 16, these articles can be understood as right to equality. And those articles cannot be amended easily because the basic structure doctrine. See, the constitutional provisions can be amended, but the basic doctrines, basic dogmas, philosophies cannot be amended. Right to equality is not only a provisions, but it is a dogma, it is a philosophy, without which our constitution will be of no use. So that cannot be amended. Okay. So when I say right of equality, I'm basically talking about Article 14. But when I'm talking about right to equality, I'm talking about Article 14, 15, and 16. So today let's talk about right to equality. Having understood the difference between equality and equity, let's come to the point called right to equality. I hope you understood the difference between right of equality and right to equality. Now, Article 14 is very simple and very popular. Okay. Now, please understand one thing. Our Constitution of India is such a document which never remains stagnant. It was developed.
7:30 बजे मुझे थोड़ा
It was developed.
पटना बाजार का उधर जाना है, फ्रूट्स लेना है, चलेगा?
It was developed over a period of time.
Please unmute all of you. Please.
Yes. Ma'am, am I audible now properly?
Yes, sir. You're audible properly. I'm requesting to all of you, please mute yourself so that sir can deliver the lecture properly. So it will be very convenient to listen. Please.
Yes, yes. Thank you very much, Alka ma'am. Thank you very much. So as I said, Article 14 is very simple provision. But before I will discuss Article 14, let us understand the importance of our Constitution. The Constitution of India never remained a statement document. See, there are various rules of interpretation, like rule of literal interpretation, rule of purposive interpretation, rule of remedial interpretation, rule of harmonized construction interpretation, and rule of wider interpretation. Basically speaking, laws are of two kinds: substantive law and the procedural law. Now, substantive law are those laws which are concerned with the rights of the people, which are concerned with the remedies of the people. Procedural law provides the platform or the forum for the enforcement of those rights. The legislation like CPC, CRPC, these are the legislations of procedural laws. The legislations like Contract Act, right? Specific Relief Act, these are called as a substantive law. Now, the Constitution of India is yet another example of substantive law. In fact, it is called as a remedial legislation. Consumer Protection Act is yet another example of what you can say remedial legislation, because it provides rights and remedies. Now, there are various rules of interpretation can be used for interpreting these kinds of legislations. Now, for substantive legislation, we have different rules of interpretation, and for procedural legislations, we have different rules of interpretation. It is well understood that for interpreting any provision of substantive legislation and remedial legislations, the court should go for rule of purposive interpretation, rule of remedial interpretation, and rule of liberal interpretation. The classic example is Article 21, Article 24 of the Constitution of India. Now let's look at Article 21. What was understood as right to life in Francis Colonial case way back in the year 1950 is something different than what we talk about right to privacy in terms of Aadhaar judgment. So look at Article 21. Look at nature of Article 21, how it was extensively interpreted. It is possible only when the legislation is substantive. It is possible only when the legislation is remedial in nature. Let's take an example of the freedom of press, Article 19. Look at the A.K. Gopalan case. The court interpreted freedom of speech in a very limited sense. But when it came to Maneka Gandhi case in the year 1978, the court gave a wider interpretation. So each and every article of our Constitution of India has been interpreted extensively and very liberally. That is possible only when your legislation is liberal in nature and remedial in nature. Another example, as I said, Article 21, which basically prohibits child employment. We have famous case of Siva Kashi case, MC Mehta versus State of Tamil Nadu. See, Article 24 simply says the child cannot be employed in an hazardous industry. But if you analyze that case law wherein the court directed the employer to pay the compensation or a fine of rupees 25,000 to the parents of the child. So such a liberal interpretation which the court gave while interpreting Article 24. So does with the Qureshi versus State of Bihar, while interpreting the religious freedom. So that's the beauty of our Indian Constitution. Having been said that, our Constitution of India is a liberal piece of legislation, is a remedial piece of legislation, and it is a substantive piece of legislation. The rules of interpretation like rule of liberal interpretation, rule of purposive interpretation, rule of harmonized construction are generally used while interpreting these articles. So when you talk about any article of our Indian Constitution, including right of equality, right to equality, freedom of press, so on and so forth, generally which rule of interpretation could involve? Rule of liberal interpretation, rule of remedial interpretation, rule of wider interpretation, rule of harmonized interpretation, so on and so forth. Coming back to Article 14, as I say, it opens with the word state shall not deny any person or equality for equal protection and equal treatment before the law in India. See the word which is used, state, any person, equal protection, equal treatment before the law within the India. In other words, it shall be duty and the responsibility of the state to ensure equal protection and equal treatment to any person before the law in India. Now, very important point is in India. So right of equality. You see, Article 14 is an example of right of equality. Now, I'm not talking about right to equality. I'm talking about right of equality. When there will be completion of 14, 15, and 16, then it is called as a right to equality. So you are expected to have equality before law in India in terms of Article 14, and that is available to any person. Now, let me give an example of Section 6 of the Patent Act. Patent Act. It's one of the popular IPR legislation. India signed various treaties of WTO, including agreement on trade relating to intellectual property rights. Article 4 of the TRIPS clearly provide that the principle of equality shall be one of the important paramount considerations. Okay. Now that principle was very much remain present under the Paris Convention. We had a Paris Convention for the protection of industrial property, which was substantially modified, and in fact it was replaced by the TRIPS. Now today, for the IPL owners, we have a TRIPS at international level. And of course, we have a patent cooperation treaty as well. Now, if you look at Section 6 of the Patent Act, it says that any person can file an application for a patent. So even if an American comes to India and if he wants to file an application for patent, he can. So my point is that equal protection and equal treatment before law to any person. So the foreigner can come to India and he can seek for the patent protection in India. Now we have another definition called Section 21F of the Arbitration Act of 1996, which defines the international commercial arbitration. If there is a dispute between two parties in which one of the parties is foreigner and the dispute arises out of legal relationship, you can say it's a case of international commercial arbitration. Now, when there is international commercial arbitration, when dispute arises, a foreigner can come and he can approach the Indian arbitrator. And it will be duty of the Indian arbitrator to ensure the equal protection and equal treatment to that person. You cannot deny merely on the ground that he is a foreigner. So understand the impact of Article 14. There is a glaring impact of Article 14 on each and every articles. So the today foreigner is entitled to have legal aid as well. We can. The famous case of Azmal Kasab. He was defended by the lawyer of the government at the cost of the government because of Article 14, because of Article 21, because of Article 39A, which talk about equal opportunities for equal protection, equal treatment before the law, equal opportunities for the legal aid. Correct? So understand one thing. When you talk about in India, in context of Article 14, here we are basically referring to independent. We have various definitions of India as defined under the various legislations, and they are extremely different. Now, independent India is different from the British India. If you look at the legislation like Gender Clauses Act, the Indian Penal Code, right? These are the legislation which had a provision for defining the term India. And what was understood as India in context to Indian Penal Code, in context to Gender Clauses Act, were much more wider than what is understood as India after independence. So prior to independence of India, India was understood as a British India. Now today we have a legislation like the Customs Act of 1967, another legislation. Today we have confined the definition of India only to the extent of independent India. So there is a difference between British India and independent India. So the Indian Penal Code, Gender Clauses Act, these are called colonial legislations. Again, on point of legislations, the jurisprudence, if you will go through it, you will understand there are various kinds of legislations, private legislations, public legislations, subordinate legislations, colonial legislations, independent legislations, so on and so forth. Among these, colonial legislation is one of the popular legislation. So the legislation which are enacted prior to independence of India, they are basically called as colonial legislations. And in most of the colonial legislation, India is understood as a British India. But after independence, India is understood as an independent India. So when we talk about India, basically it is referring to independent India to be different from British India. Okay. Now, any person, please understand me. When you talk about person, let me draw back your attention to another two legislations like General Clauses Act, Section 3, and Section 2 of Income Tax Act, and of course Section 11 of the Indian Penal. These three legislations define some person. At the first instance, the person means any being who is capable of acquiring rights and obligations. One who has a right without any obligation is not a person within the meaning of law. Therefore, a minor is not a person, and therefore he is not a competent to enter into a contract in terms of Section 11 of the contract. He is not authorized to transfer the property in terms of Section 7 of the Transfer of Property Act, and even he cannot prepare a will in terms of Section 59 of the Indian Succession. So who is said to be a full-fledged person? One who is subjected to rights and obligations. The company is a person which can sue or be sued in its own capacity. In terms of Section 11 of the Indian Penal Code, person is understood as natural person as well as legal person. So when we talk about right of equality in terms of Article 40, that is equal protection, equal treatment before the law. It is available to any person, including foreigner, as well as person of own Indian nationality. It is also available to natural person as well as legal person. It is available to all, irrespective of the nationality. Secondly, it is available within the territory of India. Right? So a person is entitled to have protection under the patent law. A person is entitled to have protection under the Arbitration Act with regard to the equal protection and equity. There are other legislations also which do. Illustrated, I would say, in terms of examples, like custom user law. The judgment delivered by the court is a law. Legislations, circulars, orders, and notification made by the government is a law within the meaning of Article 13. Correct? But here, what kind of law are we referring to? Here we are referring to the judgment. Here we are referring to what you can say, the protection which is offered by the law. See, we have various kinds of law which basically known for the neutrality, which is basically known for the equality. Correct? But there are certain laws which are what you can say special welfare sentencing, which might result into protective discrimination in certain cases. Correct? So here, when I talk about equal protection, equal treatment before the law, it includes equal protection under the legislations. It includes equal protection before the judiciary as well. Correct? Now, all of you are aware, you must have studied that reasonable classification, other things. I'm not going to go in depth. I just tell you the basic point that the state has to ensure equal protection and equal treatment before the law in the territory. Okay. Now let's go further. We have Article 15. Article 15 basically is an exception to equality. But Article 14 says everybody is equal. Article 15 basically talk about doctrine of protective discrimination. Doctrine of protective discrimination. In other words, basically talk about the access to public place. See, neutrality is one of the important. I think there is a voice. Please mute yourself. Alka ma'am. Alka ma'am.
Yes, I have done, sir.
Yeah. Am I audible, Santosh?
Yes, sir. You are well audible, sir.
Yeah. So if you look at Article 15, it is basically divided into two parts. First, it talk about access to public place, that there should not be any discrimination from accessing any public place on the ground of nationality, sex, sect, so on and so forth. Then Article 15 carves out with certain exception, which says that for the welfare of certain people like women and child, there can be a discrimination. There can be a discrimination. So at the first instance, no person can be discriminated. So you cannot deny any person from entering at the temple. You cannot deny any person from entering at a dargah. You cannot discriminate any person from entering at the mosque, church, merely on the ground that that person belongs to so and so sect, so and so sect. If he or she has been denied, will be a violation of Article 15. This is what the literal interpretation of Article 15 says. Because the temple, church, mosque, these are basically called as the public place. And access to public place is one of the important right as contained under Article 15. Correct? Then, as I said, the second portion of Article 15 talk about protective discrimination. It says that the state can make certain discrimination. What did I say? The first portion of Article 15 says the state should not discriminate. Rather, no one should be discriminated. No one can be discriminated. No one should be discriminated from entering into at the public place. So if the particular person discriminated from entering at a mall, restaurant, movie theater, it will be a violation of Article 15. Mute yourself. Further, law says, in fact, Article 15 says, for the woman empowerment, for the empowerment of the child, for the empowerment of the different labor people, the state can discriminate, state can come out with the discriminatory laws. Okay. The philosophy of Article 15 clearly state that we should not have a discriminatory laws. If we have a discriminatory laws, it will be a violation of Article 15 and Article 14. In terms of legislation, we cannot discriminate the person, right? One person will get a normal treatment, another person will get a VIP treatment. If the law is adopting such kind of technique or tactics, such laws are valid in law in terms of Article 15 and 15. Okay, so gender neutrality, what you can say the principle of neutrality and equality is a prime requisite of any modern legislation. If not, it will be a violation of Article 14 and 15 of the Constitution of India. But as I said, it has certain exception. The Article 15 clearly provides that for the empowerment of women and child, the state can come out with a discriminatory law. So for the development of women, for the progress of the child, the state can come out with certain discrimination. Okay. Now that discriminatory law might violate the principle of equality, might violate the principle of neutrality, but that is essential because of that particular weaker section of the society. Correct? Now we have certain welfare centric legislation made for the women empowerment, made for the development of child. Like we have the Factories Act, where there is a clear-cut provision that a child cannot be employed in a factory. We have a POCSO, Protection of Child from the Sexual Harassment Act. The person has been prosecuted under POCSO. The offense will be non-bailable, non-compoundable, and cognizable. Okay. And for the women empowerment, we have got certain legislation like Section 498 of the Indian Penal Code. We have a legislation like Protection of Women from Domestic Violence Act. Correct? And other legislation which may be discriminatory in nature, but it is essential for the development of the woman and child because they were understood as a marginalized sections of the society. So we have certain reservation provisions for the woman. We have certain, what you can say, preferential treatment for children. That is needed. Likewise, we have legislation for the employment of different level people. So we have rights of persons with disability act of 2016, wherein certain reservations have been given to different level people in the matter of education and employment. Correct? So in doing so, there might be a discrimination, but it is needed. So that is called as a doctrine of protective discrimination, which is an exception to Article 14. Although Article 14 says let us have an equality to all persons before law, but there are certain laws which may discriminate before law or equal protection, equal treatment on the ground of sex, on the ground of age. So under certain legislation, women may have preferential treatment than the male. Under certain circumstances, children may have certain privileged treatment than any other categories of human being. That is it. Now we have Article 16. Article 16, as I said, it is a fundamental right of equal opportunities. Equal opportunity is basically something which provides an opportunity to all people, particularly citizens of India, to take a part in the governing affairs of the state. Now, understand the background of this right called equal opportunities. We have a UDHR, Universal Declaration of Human Rights. Under that declaration, right to take a part in the governing affairs of the state has been understood as one of the important human rights. And therefore, we may have certain provisions for equal opportunities, but this provision is available only for the citizens of India. Right? Now, when you talk about equal opportunities, it basically refers to I have a right to apply for the public job, public sector undertaking job. I cannot claim these equal opportunities in the private job. So if a private company come out with an employment news and if they say that we have so and so criteria, which might lead to a violation of your right, you cannot file a case against these private entities on the ground that they did not give them equal opportunities. You cannot. Equal opportunities for the sake of public employment only is available only for citizens of India and only in government jobs. Next portion of Article 16, as I know, basically concerned with the affirmative action program. Okay. Now, before we discuss affirmative action program, let us recap Article 14, 15, and 16. Article 14, as you know earlier, right of equality. Article 15, I hope you understood protective discrimination. And Article 16 says equal opportunities to all citizens of India. Now, these three provisions basically talk about right to equality. So this is the first portion. And it is whose duty to protect? It is a duty of the state. Now, what do you mean by state? For the purpose of Article 12, the central government, state government, all government companies, and all public sector undertakings. Correct? Now, further, as I said, the affirmative action program. Affirmative action program is nothing but a reservation scheme. Whether it was necessary. See, as you know very well, India is known for the diversity. India is known for the multilinguistic. India is known for the multicultural aspect. India is known for the various kinds of caste and community. What was the reason? Some castes remain oppressed. Some castes remain marginalized. Okay. So some segments of the society did not adequately represent themselves in the governing affairs of the state, and therefore the framers of our Indian constitution felt that there should be some special treatment to them. There should be some protective discrimination in favor of these people so that they can represent themselves in the governing affairs of the state. That is understood as a reservation policy. Please understand one. Although we have Article 16.4, which basically talks about reservation, which is nothing but the affirmative action program plan of the state. No doubt it depends on the articles. or the constitutional religion. It depends on various legislation. But at the end, it depends on the economic policy of the state. If everything will be liberalized, if everything will be privatized, there will not be any government jobs. Everything will be a private job. So you can't expect the reservation in the private job. So largely it depends on your economic policy.
बघू काढ
If your
पुसून काढ
if your economic policy is of liberal in character, then don't expect that there will be a reservation policy in the private job. So to have a reservation policy more effective, your economic policy should be of more people-centered. Extreme privatization, extreme liberalization may not serve the purpose when it comes to affirmative action program plan of the state. Although in the era of globalization, it is inevitable. But still my submission will be, in the era of globalization, if you want to ensure the affirmative action program, if you want to ensure the reservation policy of the state, you need to come with the mixed pattern of the economy. In mixed pattern of the economy, as you know very well, certain sectors of undertaking still under the control and the supervision of the state. So defense is under the control of the state, education is comparatively under the control of the state, justice is under the control of the state. So anything which is under the control of the state, one can expect the reservation policies. One can expect the affirmative action program plan. But in the era of globalization, if everything is liberalized, privatized, don't expect that there will be a public job and you will have a reservation. So it largely depends on economic policy, and the nature of economic policy will decide your affirmative action program plan. Now, I'm not going to discuss the Indra Swani judgment, what is called as the Mandal judgment, and other what is that Namdar case, so on and so on. All of you are aware. I'm just telling you a little bit of it, how the economic policy matters when it comes to affirmative action program. Right? So let us recap. Till now, what we discussed the concept of state, we discussed right of equality, right to equality, protective discrimination, equal opportunity, affirmative action program plan, etc. etc. Correct? Now let us go a little bit further. Let us talk about freedom of speech. Now, whether this freedom of speech is available to the private entities. Okay. Now, in context to company law, there are a number of cases like Bennett Coleman case, STC versus CTO, wherein the court has made an observation that company is not a natural person, company is a legal person, and in doing so, company is not a citizen. So at the threshold, the company cannot claim the fundamental rights called freedom of speech and expression, which include freedom of press. Still remember, there was a movie called Around the World in $8, which was released by the Taj Kapoor. Why he released a movie called Around the World in $8? Because that time there was a restriction on the foreign currency. You were not allowed to hold certain currency in excess of the limit prescribed by the RBI. So there were a limitation that you cannot hold the currency. And that time I think the government was giving them $8. So then he said, let us have a movie called Around the World in $8. How can you have this word to with $8? But because of the legislative restriction. Similar kind of restriction was there on the press circulation. You cannot have certain papers in excess of the quantity prescribed by the government. That was the era of 1947 and 1949. That was needed because of nature of economic policy which we had adopted immediately after independence. Immediately after independence, most of the sectors were under the control and supervision of the state. Today, when we are talking about freedom of speech and expression, we are referring to freedom of press. I'm talking about freedom of press. Now, when I say freedom of press, we are referring to the print media and electronic media. Please, I repeat again, when I say freedom of press, it is available only to Indian citizens. It is available only to Indian citizens. When I say Indian citizen, basically I am referring to natural person. So at the first instance, the foreigner cannot claim freedom of place. Okay. And the corporate entities cannot claim freedom of place. Cannot claim. Okay. And then what we talk about print media and electronic media. Yes, they have a freedom of expression, but as a corporate entity, as a legal entity, they cannot. An individual proprietor, individual entrepreneur may have what is called as the freedom of press, freedom of speech and expression. Now, as I already discussed, freedom of speech and expression and other fundamental rights are not absolute. They're conditional. They're relative in nature. Okay. Now, I would like to compare freedom of press with that of the freedom of religion. Now, freedom of press is subject to limitation, and freedom of religion is also subject to certain restrictions or subject to certain limitations. Okay. Now, first, understand what Article 25 is, which talk about freedom of religion. It is condition precedent. It is condition precedent that your religious freedom should not be opposed to public policy. It should not be immoral. In other words, it is understood as a condition precedent that your freedom of religion is moral. It is not injurious to the public health. It is a presumption. So anything which is opposed to public policy, anything which is immoral, anything which is injurious to the people cannot be allowed as a freedom of religion. So it's a condition precedent, which is not the case with regard to with regard to freedom of press. At the first instance, it is presumed that you have freedom of press, right? You have a freedom to express your opinion. You can. Nobody will interfere. It will come into question only when it is complained of, only when it is challenged by someone else. So the limitations are of conditions subsequent in nature. That is in terms of Article 19(1)(g). So as I told you, the freedom of religion and the freedom of press both are conditional in nature. But the freedom of press is subject to conditions subsequent, and religious freedom are subject to condition precedent. So you can't have a religious freedom at the first instance if it is opposed to public policy. You can't. Whereas in case of freedom of press, you are allowed to speak. Unless it is challenged by someone else, unless it is complained of by someone else, you have a freedom of press. Everything is presumed to be valid so long as you are talking and so long as it is not objectionable to other. Moment it is objectionable to other, Article 19(1)(g) comes into action. Article 19(1)(g) of the Constitution of India, which talk about doctrine of reasonable restriction. State has a right to impose a reasonable restriction on your freedom of press, okay, on the ground that it is contrary to public order, law, and morality. Now, what is reasonable restriction? Reasonable restriction is a question of fact and question of law. See, it reminds me Order 14 and Order 15 of the CPC. And of course, Section 5 of the Evidence Act is basically talk about fact in issue. Understand this, what is this issue? And then you will understand what is called as a question. The question means issue. If A makes certain allegation against B, and if B do not deny it, it is admitted, there is no issue. In fact, Section 57 and Section 58 of our Indian Evidence Act clearly provide that the facts which are admitted by other parties did not require to prove. So if I make certain allegation against B and if it is not denied by B, then it is admitted that B has no objection to my allegations. This is what section 56, 57 and 58 of the Evidence Act covered, which is called as the Doctrine of Judicial Notice. Correct? Now, as I said, question of fact and question of law. These are called as the two kinds of issues. Order 14 and Order 15 of the CPC basically talk about the issue of fact and issue of law. Now, whether A has taken the money from B or not is a question of fact. Next issue arises, if A has taken agreement from B, whether that agreement is valid or not is a question of fact. And sometimes it becomes a mixed question of fact and mixed question of fact. So my point is that the state has a right to impose a reasonable restriction. It's a question of fact. Now, if your freedom of press is against immorality, if your freedom of press is immoral, the state has a right to impose a reasonable restriction. Now, what is morality and what is immorality? See, there are certain laws which are known for the moral legislations. There are certain laws which are known for the principle of morality. The legislation like Indian Penal Code is a classic example of recognizing certain principles of morality, like section 378 of the IPC, which provide the punishment for theft. Section 377, offences of unnatural lust. Section 497, offences of adultery. These were the offences which were made punishable because they were morally wrong. Understand one thing. It is not necessary that law should be morally incorrect. What is expected is that law should be neutral and law should be rational in character. Neutrality and the rationality is a prerequisite of any modern legislation. But if you look at the pre-colonial legislation, pre-independent legislation or colonial legislation, they were known not only for neutrality, rationality, but they were also known for the morality. Indian Penal Code is a classic example. Indian Evidence Act is a classic example of principle of morality. Indian Contract Act is a classic example of morality. Some provisions are based on the principle of morality. In contrast to that, the modern legislation may not take into account the principle of morality. However, the Constitution of India do take into account the constitutional morality. Like you cannot exercise the freedom of press, freedom of speech if it is immoral in character. You cannot have a freedom of religion if it is immoral in character. In fact, definition of law in terms of Article 13 also give more importance to the custom. Custom is one of the important sources of law. And in fact, custom has been recognized as Section 7 of the Indian Marriage Act, as you know very well, clearly provided marriage cannot be completed unless it is performed according to a virtual ceremony or ritual ceremony, which include Kanyadan, Panigrahan, so on and so forth. So custom is one of the important sources of law. In fact, custom is a law in terms of Article 13. But it is not all custom which is a law. Practicing sati was recognized as a custom, but since it was called as immoral or opposed to public policy, it was struck down. Although it was a custom, but it is not a law because it is immoral. It was regarded as opposed to policy. So when we talk about morality, as I said, it is one of the grounds to impose a reasonable restriction. So you can't have a freedom if it is immoral in character. But who will decide what is moral and immoral? Understand one. Legislation cannot decide what is moral and what is immoral. The classic example is decriminalization of Section 377 and Section 497 of the IPC. Way back in the year 1860, offences like adultery were criminalized on the ground that they were immoral. In the year 2019 and 2019, we firmly believe that offense of adultery cannot be regarded as immoral. Unnatural offenses cannot be regarded as immoral. So concept of morality cannot be a task of legislative body. It is purely a question of fact. It cannot be a question of what is moral and what is immoral. It cannot be a question of it has to be a question of fact. So it is a more important responsibility of the judiciary to decide what is moral. No doubt the framers of our Indian constitution have made a general statement that if your freedom of press if it is immoral, you have a reasonable restriction to ban the same. But what amounts to morality and what does not amounts to morality, who will decide? No legislation can decide. Because once the legislation is made, the legislative body becomes the police office. Yes, we can come out with certain amendment, but hardly we anticipate any amendment once the legislation is passed. So, say for example, if there is a legislation on the morality, how do you expect that this morality will remain stagnant? The morality keeps on changing from time to time, place to place, and person to person. Likewise, the violence will have a concept of domestic violence, emotional violence. In terms of Section 3 of the Protection of Women from Domestic Violence Act, it keeps on changing, absolutely relative. So, a freedom of press cannot be exercised if it is immoral, if it is opposed to public policy, if it is against the principle of morality. But legislation cannot decide what is moral and what is immoral. It is the judiciary who can decide what is moral and what is immoral. But while deciding the fact, what is moral and immoral, practice which is followed by the community, the rationality behind it, ethics behind it, should be kept in mind. It is not the scientific research and development should be the whole and sole criteria while deciding what is called by the freedom of press, what is called as a morality and moral. No, it is not. If you declare any particular provision as moral, which are essentially immoral, try to understand its impact on the society as a whole. Today, if you are decriminalizing certain penal provisions, you must anticipate the impact on the society as a whole. Theory of social engineering is a classic example. It says, Descopon says, the judgment must have anticipated impact on the society. While making any law, while pronouncing any judgment, one must anticipate what kind of impact it may have on the society. If the society will follow the law, whether the society will follow the judgment or not, we must keep in mind. So the same place may lie for the principle of morality. Today, if you say that yes, this is moral, whether people are going to follow it or not. Today, you say that this is not immoral, whether people are going to follow it or not. So that parameter should be kept in mind. So when you talk about the freedom of press, please understand one thing: you have a right, but it is subject to reasonable restriction. Now, when I say freedom of press, what were the scientific research and development which took place? It basically refers to electronic media, print media, multimedia, so on and so forth. Today we are talking about the social media. Social media is an emerging trend with regard to freedom of press. Correct? So today social media is exercising its right. Correct? With regard to the freedom of press. So these are the scientific research and development which has taken place with regard to freedom of press. Okay. Of course, there are certain conflicting issues and challenges which are arising. Right? Say, for example, in the matter of social media, it is whose responsibility, it is whose liability with regard to freedom of press. In context to electronic media, it is whose liability responsibility in context to freedom of press. Okay. There are various issues which requires a strong consideration, which need to be resolved at the early stage with regard to freedom of press and the scientific research and development in context to freedom of press. Okay. So today we finished these few provisions like right of equality, right to equality, affirmative action, equality of opportunity, freedom of press, the scientific research and development, of course, conflicting issues and challenges. I think, shall we stop here today? So this more or less finish it up here, model. Of course, there is one part which is left out, women empowerment, that you can do it very well. Women empowerment basically refers to what kind of laws we have for the empowerment of women. Like we have various kinds of laws for the empowerment of women. We have Domestic Violence Act, we have Factories Act, we have Maternity Benefit Act, correct? We have Minimum Wages Act, we have Equal Remuneration Act, okay? Then we have a law which protects the woman from the sexual harassment at the workplace, like Vishak and others versus State of Rajasthan. Okay, a number of legislations which are made for the protection of women. That is called as woman empowerment. In fact, after the incidents of Nirbhaya, we had a Justice J.S. Verma committee who strongly recommended certain reform in IPC, and we had certain legislative reform in IPC. Therefore, we find a provision called 354A, 354B, which is concerned with the outraging the modesty of woman. Then we have section 509, again, which deals with outraging the modesty of woman. Right? So we have various legislations for empowerment of women, which you people can go through the same. Correct? So we stop here today. Okay?
Yes, sir.
Yeah. Yes, any question?
So I have a query, but it is not regarding the lecture actually.
Mm-hmm.
So it is not regarding the lecture, the query.
So you can sort it out from the office, no, ma'am?
Sir, actually, I don't live in Mumbai, and so that's why it's actually regarding my son.
Madam, let us close this issue and then because
Yes,
let
sir.
us
Yes,
close.
sure, sure.
You can call me. Santosh, let us wind up, Santosh?
Yes, sir. Yes, sir. We can wind up this call, sir. Thank you
Yeah.
very much. Very nice presentation by you, sir.
Thank you.
Really appreciate. Great, sir.
Thank you. Thank you.
Thank you very much, sir.
Thank you. Thank you. Thank you. Sarika. Yeah. इकडे ना ते बंद कर. पहिला माईक बंद कर, माईक आली. माईक आली. माईक बंद. You know. Not one sentence.